It is May the 4th of 2026, and may the 4th be with you. We're starting off today with Judge McNally hearing a domestic dispute sparked by a text message, a probationer who vanished after rehab, and a double assault case. Then we see a tenant completely lose her cool, repeatedly interrupting the judge over bounced check fees. But we're not done. We switch to Judge DiSanto to deal with a high-speed chase suspect, the driver who got busted drinking with her interlock device, and a habitual car break-in suspect who forgot his court date. And we're still not done. To cap it all off, we've got a defense attorney begging the court to let him quit the case after getting a bizarre 5-page manifesto. The 4th is strong with these judges, ladies and gentlemen, and it all starts right now.
People versus, I'm going to just take the one on the top there, guys. Parrott, Dalton James Parrott, 267100092. All right, Sergeant, your name?
Sergeant Aaron Irish County Police Department.
All right, raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings.
I do.
Wait a minute. Is this supposed to be mine?
Oh, I mean, she said it was. We switched to the
I'm on the state docket.
state document.
Yeah, I know. So, okay, whatever. All right, I'm going to do it anyway. I'm sorry. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do.
Go ahead.
Your Honor, on May 1st, 2026, at approximately 9:45 p.m., Trenton PD officers were dispatched to 3376 Van Horn Road, apartment 272, in reference to a domestic assault. Officers arrived and spoke with the victim, identified as Maya Merrow. Merrow stated her ex-boyfriend, identified as the defendant, Dalton James Parrott, with whom she has a past dating relationship with. The defendant was going through the victim's cell phone and observed a text message that made him upset. And at some point, the defendant grabbed the victim by the throat, held her up against the wall for several seconds. The defendant then threw the victim to the couch and continued to choke the victim. The victim stated she never lost consciousness, but she could not breathe and did start to panic. The defendant did finally let her go, gathered his items, and left the apartment, where she was able to call 911. The defendant was observed walking down Van Horn Road, where he was stopped by Trenton police officers and subsequently arrested. We did take digital photographs of the victim's throat showing injuries, and the victim did go to the hospital on her own after being checked out by the Trenton Fire Department.
All right, so they used to date. This is her ex, right?
Yes.
Based on your sworn testimony, I find the crime of assault with intent to do great bodily harm less than murder by strangulation was committed. There's probable cause to believe the crime was committed by the defendant and authorized the issuance of the complaint and the warrant for the arrest of the defendant. All right. For your appearance.
P78413, I'm a DC counsel representing Mr.
Sir, your name?
Dalton James Parrott, Your Honor.
All right. So for purposes of arraignment, how does he wish to proceed?
Your Honor, when we formal reading stand mute, ask the court to enter a not guilty plea.
Sir, you have the right to remain silent. You do not have to say anything. If you say something in or out of court, orally or in writing, it can be used against you. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. And if you cannot afford one, you would be appointed one at public expense. Also, if you choose to submit to question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, Your Honor.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, Your lawyer will discuss this case with the prosecutor at the preliminary examination. The people would have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the circuit court. If they fail to prove that, then the case would be dismissed and you would be discharged. Do you understand that?
Yes, Your Honor.
Probable cause conference will take place on May the 12th at 8:45. That will be in front of me. I'm not sure why they have Judge Hussin's name on this. And then May the 19th will be the preliminary exam at 10:15, both of which will be in front of me. What would you like to say regarding bond, counsel?
Your Honor, I would like to, I spoke to, Mr. Barrett. Currently he's working, doing, I believe he works for the College of, excuse me, I'm sorry. He's working at, Vincent Tower, making, wind turbine blades. He's been doing that for the past 6 months. It's a good paying job. He's also, prior to that, he was doing maintenance, doing, overhead crane and vault manufacturing, for a local company. He currently has friends and family, or friends in Toledo, which is where he plans to stay, once it's released on bond. He has, no open wants or warrants, and his criminal history is clean, at least for the past 10 years. He has no failures to appear for it. Based on the nature of the charges, he understands how serious they are. When we would ask the court for a personal bond in his case, because among other things, the Trenton Police Department has not asked for a cash bond.
Sergeant Benars, do you have anything to say on bond? And I would like you to be a little more specific with regard to the injuries that they ascertained or observed on the victim.
The victim showed redness on her throat. They did go back the other night and take pictures, which I have not seen yet. That was a request of the prosecutor. I cannot speak to those because I have not seen the photographs yet.
What are you asking for bond-wise?
Yeah, I will leave that to the discretion of the court.
Listen very carefully, Mr. Parrott. I'm going to give you a personal bond, but you're to stay away from that victim. Do you understand me?
Yes, Your Honor.
$10,000 personal bond. You can leave the state to go to Ohio.
Okay, thank you.
Otherwise, you cannot leave the state. You can only go to Michigan or Ohio. You cannot violate a law. You must appear in court as directed. I'm telling you, no contact with Maya Merrill. You cannot write, phone, see, text, email her, or communicate with her in any way. No assault, abusive, or intimidating behavior toward her. You're not to enter the property address at 3376 Van Horn Road, apartment 272 in Trenton. No alcohol. Was there alcohol involved in this, Sergeant, or marijuana or illegal drugs?
That was not related to me. I don't know.
I'm going to go ahead and delete that. I'm not going to order that. No firearms, no dangerous weapons. You're not to purchase, possess, or consume any one of those. You are not to be within 2 miles of the victim, her residence, or place of employment. So I'm not going to order a GPS tether. I want you to be clear with me, I want to be clear with you, Mr. Parrott. If I ordered a GPS tether, you're going to be sitting in the county jail for 5 days until they can fit it. I'm not going to do that.
Thank you, Your Honor.
But I'm telling you, if you have any contact, you have somebody call somebody who calls somebody who calls somebody who calls her, you're going to be sitting in jail for a long time. Do we understand one another?
I understand you, Your Honor. Thank you.
All right. So your court date will be on May the 12th at 8:45, and then May the 11th or May the 19th at 10:15. Okay.
I'm going to copy that from you guys, right? Okay.
Thank you. Thank you very much. Have a good day.
Thank you, Your Honor. You too.
Thank you, Sergeant. People against
Have a good-
Sluter. Drake Allen Sluter. 24B146556. Mr. Sluter, come on up here. State your name, counsel, your appearance.
Morning, Mayor. Peter Bernard.
Drake Allen Sluter.
MIDC counselor for Mr. Sluter.
He was supposed to be here on May the 4th for a show cause. He's had no prior technical violations. On June the 18th of 25, I placed him on probation under section 771.1 for a period of 9 months. And then I ordered that he reappear in person on, he appeared on March 4th. Yes, on March 4th of 26. He failed to appear on this warrant. There are 2 counts: failure to attend and complete two of 3 days on the court work program, and failure to pay fines and costs as ordered. How is he going to proceed on these?
Your Honor, I spoke to Mr. Sluter. He's going to plead guilty to both of the counts. I would also make note to the court, make note that he missed this hearing because he was actually in rehab at the time, in inpatient rehab.
All right, sir, if you plead guilty here, I do want you to understand that would be 2 technical violations. You haven't absconded for 60 days, I suppose, because you were picked up. But no, I guess it is 60 days today. So your probation could be revoked. Let me think. April 57. Yeah, it's 61 days. Your probation could be revoked, and you could be incarcerated on this for 90 days with your 771 status revoked and the conviction entered. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all of those rights, and we are not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. To the charge you failed to attend and complete 2 of 3 days on the court work program, how do you wish to plead?
Guilty, sir.
Did you fail to attend 2 of 3 days on the court work program?
Yes, because
I want to know if you failed to attend that, sir.
Yes, I did.
And then as to count 2, the charge you failed to pay your fines and costs as ordered, how do you plead?
Guilty.
You failed to pay your fines and costs as ordered.
Yes.
Anybody force you to plead guilty?
No.
I'll accept your plea to both counts. Why wasn't he here? He was in rehab for how long?
Mr. Sluter, how long? When did you get released from rehab? Your hearing was on March 5th.
I was released from rehab in March, but I was also taken to Lake Ridge, which where I was also placed in rehab there under their custody, which I just got released from there not long ago.
When?
About 2 weeks ago.
Why didn't you come in here?
I didn't. I was gonna come and take care of all this. I just
When?
like
Tomorrow, right? You know how many people told me
Yes.
tomorrow?
Yes, sir.
You can't do this, son.
I know.
Detective, can I have your name back there, please?
Detective Violator, Brownstown PD.
Do you live in Belleville, Mr. Sluter?
Yes, at the moment I do, but I'm trying to get back into another sober living.
Where was he picked up, Detective?
Your Honor, I'm not sure of that.
It was in Detroit.
He's a passenger in a car in Detroit. I believe he's been incarcerated since the weekend. Mr. Sluter, how long have you been in custody? Since Friday?
Since Friday, yeah.
Call in, Jessica. You got to take care of things, sir.
I understand.
I mean, it's great that you're going to sober living and all these other places, but you can't ignore your obligations. You could have gotten online from a facility, and that's number one. And number two, you should have shown up here the day of, and that's assuming you went the day that you were released, and that's assuming you went. I don't have any proof that you went. Do you have any proof that you were there?
Yes, in my property, but I don't have any of my property with me.
This is not good. I need your name, please. So he was picked up. He says he was in inpatient facilities. Do we have any proof of that?
Yeah, he's been in and out of inpatient facilities pretty much the entire time I had him on probation. The last proof of him being inpatient I have was January 28th of 2026. They sent me a letter of Sacred Heart stated that he was inpatient at that time. I don't know if he was released or anything though. I never got a release report from it.
You know, you had other misses on this case too. You know that, right? You got to grow up.
I understand, sir. I'm sorry.
You don't have to apologize to me. And by the way, picked up another charge, right? When were you going to tell us about that? Whatever happened with that case out of Van Buren? Possession of meth.
I was supposed to, I went back to court and it was supposed to get dropped down to probation through them. But with me being in treatment, I never was able to go back to court.
So you didn't go there either, huh? You graduated, get the screening, the pre-sentence. Did you graduate?
Yes, I did.
Mr. Sluter,
Yes,
you're 23.
25.
Okay, I'm sorry. You were 23 at the time we did this, handled this case. You're not doing too good. You used up your quota of criminal convictions between now and the time that you're 98. Do you know that? I'm serious as a heart attack. It's time to grow up. You're living with your grandma, right?
At the moment, yeah.
But why are
right
you
now,
living with your grandmother? Because you're not getting out, you're not working, right?
Yes, I've been working.
Well, I'm just telling you. Shame on you. You're 25 and you're living with your grandmother.
Yes, sir.
Look, I don't have any choice as far as I'm concerned. I mean, he's coming up. There's no way he can do the court work program days and pay his fines by June the 18th. I'm revoking your 771.1 status.
Right.
I'm entering the conviction. Yeah, you're not doing too well. You got in with the wrong crowd, huh?
Yes, sir.
Yeah, you got in with the guys that you just don't want to be within 48 miles of, you know? And not even 48 miles unless you don't have a car and you only have a bicycle. I get the feeling sometimes, Mr. Sluter, it bothers me to see people ruin their lives more than it does them. You know that?
Yes, sir.
You can go to rehab all the days you want, but you keep hanging around with the same thugs. And then that's what happens. You follow me?
Yes, sir.
All right, I'm going to sentence him anew. Give me a first page of a register, please. I'm going to sentence him anew. I'm revoking his status, entering the conviction, and we'll go from there.
Thank you.
Anything else?
I think we covered it. I just wanted to let you know that he is working full time at the College for Creative Studies in Detroit. He's doing maintenance there. He's stable. He's living with his grandmother, who's in the line on a place to have his own place in Detroit. And again, he's been incarcerated since Friday.
Can I ask a question, Mr. Sluter? How many days were you? Now, I don't want you to embellish. I do not want you to embellish. You said that was January 28th, right? And that was from, and they said he'd been in there how long?
At that point, they just stated that he was inpatient there and that he had gone inpatient on the 28th. And the letter was just stating that he's there. The maximum time that he would stay there would be about 30 days, but his average length would be 10 to 21 days. But it was just when he was admitted. They never sent anything to tell me after how many days he completed.
Right. How long were you at Sacred Heart? And I can easily find out, so don't lie to me.
I was there for 21 days. And then I left there.
So you got out, hang on. So you got out sometime around February 18th. Then where'd you go?
And then I went to Lake Ridge Village.
How long were you there?
Detroit. I was there up until recently, maybe about a couple weeks ago.
Hang on a second. hang on. From February 18th until sometime in the third week of April. Is that where you're telling me what you're telling me?
Yeah.
You were in? Then you didn't show up on your circuit court case, right?
Yes, sir, because I was in Lake Ridge Village at the time. And
And
it's
you've been
hard
out
to
how
get
long?
a couple weeks now.
And you didn't go over to the circuit court and surrender.
I'm sorry.
I'm sorry?
I do apologize, sir.
You don't need to apologize to me. I'm not the one serving the jail time. That's your gig.
Judge, I will say too, when he was sentenced, we did have proof he was sentenced June 18th of 2025. At that time, we had proof that he was in Sacred Heart and then also in a sober living facility since April 1st of that year. So he'd done about a little over 2 months either in Sacred Heart or in a sober living facility at the time that he was sentenced.
Whoever's got the phone has got to leave the building, please. You got to take the phone out of the building, please. Thank you. 100 fines, 250 costs, 75 victims' rights. So I'm actually we're gonna do away with the $620 plus any late fees on the fines. I'm only gonna charge you 100, 250, 75, 50. So that's victims' rights and $50 justice assessment. So your total's 475 and 17 days. Credit 5, serve 12 more. You're going to serve an additional 673 days if you don't pay your fines. I'm going to let you pay those at the rate of $50 per week. I'm going to start that beginning on June the 22nd. Now, if you don't have the money, no problem. Call the court. We'll go on Zoom, or you can come in here and talk to me, and I'll be glad to give you an extension, okay? But if you ignore me, you're going to serve the other 73 days. Do you understand?
What about today? Like, how am I going to get out of here?
You're in custody now. I gave you 17 days and I'm crediting 5. You're serving 12 more.
Okay.
Good luck. Thanks, Mr. Granata. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yes, sir.
All right, good luck. Matthew Blake Leone, 26G710217. Detective, your name?
Sergeant Gary Robinson, Gibraltar Police Department.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you give in these proceedings will be the whole truth, so help you God. Mr. Leone, I'm not swearing you to an oath. I'm swearing the detective. So don't answer that, okay?
Sorry.
Did you say I do, Lieutenant or Sergeant?
I do.
Thank you. Go ahead.
Sure, this is a domestic violence.
Wait a minute. No. I got to take hang on. Slow down. I got to do the signing on record first. So so Mr. Leone doesn't put his hand up again. And so we just start slower. Put your hand up again, Sergeant, please. Do you solemnly swear or affirm the testimony you'll give in these proceedings will be the whole truth, so help you God?
I do, Your Honor.
Okay, go ahead.
On 5/3/2026, at approximately 01:30 hours, Sergeant Seifert and Officer Leza were dispatched to 13924 Waters Way in the city of Gibraltar for domestic violence disturbance. The call was lost. Dispatch could not get contact. When they did arrive, they spoke with 3 individuals at the residence. Miss Shaylin Brilletta, which is one of the victims, and Rochelle Burris. Rochelle said there was an argument that started in the bedroom where she was pushed and her hair was pulled by Matthew Leone. Shaylin Brilletta said she came into the bedroom to see what was going on and saw that there was a physical fight going on. She approached Mr. Leone and she was pushed, and then she was punched in the face by Mr. Leone. A third subject, who was just a witness, came in to break up the fight, and he was not assaulted during the altercation. Officers placed Mr. Leone under arrest, and he was transported to the Gibraltar Police Department for booking.
Wait a second. I didn't hear anything. Maybe I misunderstood, but what about Rachel Burris? Was she assaulted?
Yes, yeah, I said she was pushed and then her hair was pulled, at the beginning of the disturbance.
All right, but maybe I misunderstood. I thought you said Grilletta. What happened with Grilletta then?
Grilletta was pushed and then punched in the face after
I
the assault
see.
of Rochelle.
What's his relationship with Burris and Grilletta?
Mr. Leone is dating, Rochelle Burris, and Mrs. Grilletta is the daughter of Rochelle Burris.
Got it. Based on your sworn testimony, I find the crime of domestic violence, 2 counts, one involving the victim, Rachel Burris, and the other involving the victim, Shaylin Grilletta, were committed. There's probable cause to believe those crimes were committed by the defendant unauthorized. The issuance of the complaint and the warrant. Does your client stand mute and waive formal reading here?
Yes, sir.
Mr. Leone, your name again.
Matthew Blake Leone.
You have the right to remain silent. You don't have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
I can't hear you.
Yes, sir.
You have the right to be represented by a lawyer today and in all subsequent court proceedings. And if you ever choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
All right. So, do the 2 of them live, detective, with Mr. Leone at this address of 13924 Watersway Drive?
Yes, Your Honor, they all live together.
And who owns the house?
I believe they're both renting it, Mrs. Burris and Mr. Leone.
Any reason to dispute that, counsel?
I believe that, I thought that the apartment was in Mr. Leone's name, but I had no reason to question.
Okay, are you
Your Honor.
wait a minute, are you pretty accurate on your comment here that they both rent the property, Sergeant?
Miss Leone, Miss Burris says that she rents, she's on the property. But Mr. Leone said he is also on it there too, so I'm not 100% certain, but they both live there.
What kind of a record does Mr. Leone have?
His CCA shows nothing.
Do you work, sir? And if so, where do you work and how much do you make?
Yes, sir. I work for Lions Towing in Woodhaven. I average anywhere from 600 to 800 a week take home.
All right, here's what I'm going to do. I want to be clear. I'm going to give you a personal bond, but you are to stay away from those victims. Do you understand that?
Yes, sir.
I'm going to give you a $2,000 personal bond, but listen very carefully. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed. No contact with Shaylin Grilletta and or Rachel Burris. No contact with prosecution witnesses. You cannot go back to 13924 Watersway Drive in Gibraltar. If you have property there, like clothing and shaving cream and the shaving gear and the like, toothbrush, whatever, you can go back, but once and only with the police. You can't go back there without them. So you'd have to make arrangements for Detective Robinson and or some other police officers at Gibraltar to meet with you. You're not to possess firearms. You're not to possess dangerous weapons. You're not going to have to obtain a tether, because if I made you get a tether, you're going to be sitting in the county jail for 5 days, which would be no fun. But you're not to be within 2 miles, of the victims, their residence or place of employment. Also, you cannot leave the state without consent of the court. You cannot violate a law. You must appear in court as directed. I'll give you a personal bond. Your pretrial date will be on May the 12th, and that will be at 9 o'clock in the morning. Do you understand that?
Yes, sir.
All right. Any questions?
No, sir.
All right. Good luck. We'll see you here on May the 12th. If you think you need qualify for a court-appointed lawyer, you're going to have to fill out a petition for one. You're entitled to one on the first day, but not after that, unless I'm convinced you're indigent. Okay, sir?
Yes, sir.
All right. Anything else, Detective?
No, Your Honor.
Anything else, Mr. Grana?
No, Your Honor.
Thank you very much. Good luck, sir. Thank you. Do I have Miguel Martinez versus Tammy Muniz, 2601723?
Yep,
Good morning,
Your
Miss-
Honor, Mr.
Yeah.
Martinez, I'm here.
All right. State your full name if you would, Mr. Martinez.
Miguel A. Martinez.
Ms. Munoz, your name? Unmute, please.
Tammy Ann Munoz.
So what's going on here? Were you two living together at 3714 and you just did you split up or something? Or just tell me what the short version is?
The short version, Your Honor, was I let her, she was disabled and I let her stay here after she was getting evicted from another location. And we have come to an agreement that she'll be moved out here shortly.
So I'm going to give him a judgment, ma'am. Is that true?
Your Honor, I wasn't evicted at my other place. I was injured.
No, I don't need to know about that. I just want to make sure.
Okay.
Are you in a moving car? Come on.
I'm driving.
I can't have people in cars. Come on. Come on.
I'm sorry, Your Honor. I'm sorry.
I'm sorry.
Yes, I'm sorry. Is my daughter driving me because I got an injury?
Pull over the car.
And
Owner's Management versus Kelly Woolworth, 2601718. She needs to pull the car over.
okay, sorry, Your Honor.
Mr. Lechner, your name?
Good afternoon, Your Honor. Attorney David Lechner, P number 67994 on behalf of Owners Management.
Is Kelly Woolworth here?
I am here. I'm not the one that was in the car, though. I'm sorry, Your Honor.
You what?
I'm not the one that was in the vehicle.
No, I know. Next time you have to have your full name on there. We don't know what Kelly. There's a million Kellys. You know what I mean? Your name, please.
I apologize, Your Honor. My name is Kelly Woolworth.
That's okay. So this is for termination of tenancy. Wow. Did you listen to all the rights on the video?
I did, Your Honor.
Did you understand all the rights?
I did.
Do you wish to speak to a lawyer?
I do not have a lawyer currently at this time, but I have spoken to the attorney that's on the breakout room today.
Well, he represents Owners Management.
Your Honor, if I may, we were here last week. We got an adjournment for Ms. Woolworth to speak to Lakeshore Legal Aid. She told me she called them and never got a call back. So here's my suggestion for today. I'm asking for an adjournment so she can either reach out, try and have Lakeshore talk to her again, because that's unusual. I know Lakeshore's, whether or not they represent somebody, they're usually pretty good about getting back in touch with the client. But also I want to talk to my client to see how we can potentially work this out. So if we can get an adjournment for 1 or 2 weeks so we can.
What do you want, 1 or 2?
Whatever's good for the court, Your Honor.
I could care less. I'll give you 2 if you want. May 18th at what time?
Can we do it in the morning, Your Honor?
We can do 8:30. You've got some
8:30.
pre-trials in the morning.
May 18th at 8:30. Ms. Whitworth, make sure you get a hold of Lakeshore. Will you do that for me, please?
I will. Thank you, Your Honor.
Call them multiple times, though, okay? Because sometimes they're not as quick about getting back.
Okay. Thank you, Your Honor.
All right, thanks. Are you pulled over, Ms. Bensick? Ms.
Munoz? Yes, I am, sir. Yes, Your Honor.
Okay. So I'm going back on Martinez versus Munoz, 2601723. Your name again, Ms. Munoz?
Tammy Ann Munoz.
All right. Ma'am, any question but that you are going to move out by May the 14th?
Okay, so Your Honor, I mean, I know you don't want to hear all this, but is June, July is the only apartments that I could get into. I've been trying to look at apartments, consumer housing. I've been on the list in 2010 since my first accident. And so I'm on the waiting
you haven't heard
list,
from
but
them since 2010. They're probably not going to help you out. How long can you give her, Mr. Martinez, to get out?
Your Honor, I'm willing. I do understand she's been looking for senior housing for disabled seniors. I'm willing to give her till is July 1st okay?
July or June?
July would be okay. I'm willing. I know she's been looking.
And I appreciate that. I appreciate that.
Oh, he's going to give you all the way until July 1. Do you agree with that?
Yes, Your Honor. I appreciate
She's
that.
not driving again, is she?
And
Is she driving again?
no.
No, she's pulled. I
So
believe
you
she.
can get out I'm with my daughter.
No, but you're in a car and you're
I'm
still
pulled
moving,
over.
aren't you?
She's getting up. Get out the car.
No,
Tammy.
Your Honor. No.
You're not
Okay,
moving?
I'll get out the car. No, I'll get out the car, but I'll try to get out the car because I have a little concussion. But I'll get out the
July
car.
1. July 1, okay? You have to vacate by July 1, and I'm going to fill out the judgment. You can do that, you think?
Yes, Your Honor. Hopefully, yes.
You got to be out by the 1st, or you're going to be evicted, okay?
Okay, yes, Your Honor.
Here's what complicates this. That's 57 days away. Jeez.
I was just being courteous, Your Honor.
I know you were, and that's okay, but there's a 56-day rule. So,
Okay.
do you agree to waive the 56-day rule, ma'am? In other words, he's supposed to have to file a motion after 56 days. Actually, May the 4th, would that be what, 27, 58? Yeah, you can't do it. Do you agree to waive the 56-day rule so he doesn't have to file a motion and he can just come in here on the 1st if you're not out and file an application for a writ?
This is my first time doing this, Your Honor. Like I said, I'm trying to get a place, and it's telling me to June, July, and
He's giving you 60 days, 57, 8 days. I mean, that's
60
pretty
days.
good.
60 days. I think. Yes. I think 60 days.
Do you agree to waive
I
the
appreciate it.
ma'am? Do you agree to waive the 56-day rule for him? He's being courteous to you.
Yes, Your Honor. Yes.
So you understand he doesn't have to file a motion then if you're not out by July 1. He can just come up here on July 1 and file an application for a writ, and I'm going to sign it. The bailiff's going to go out and remove you. Do you understand that?
Yes, Your Honor.
All right. So you agree to waive that 56-day rule, correct?
Yes.
All right. Judgment for plaintiff. I filled that out, Jennifer. You can send that out. You are all set, ma'am. I sincerely wish you well. Good luck to you, eh? Sir,
Thank you,
luck.
Your Honor.
Good luck to you too. Thank you very much. Southwick versus Shelley Moore, 2601543.
Good afternoon again, Your Honor. Marlene is shown for the plaintiff P69505. I'm appearing for the attorneys of record today.
Okay.
Your Honor, it's
your name?
Shelley Moore.
All right. Did you two talk, Miss Schoen?
No, Your Honor, I haven't spoken with Ms. Moore. I understand that she filed a motion requesting an adjournment of our last scheduled hearing. We never received a copy of that motion. I understand that she was then going to be submitting bank records, attempting to prove that all payments had been made timely. We've received no bank records. So I'm just a little concerned that where some basic service requirements have not been met.
Anything?
Yes, I came in and I did not know, I called that all my originals, I came in last week on my day off. And they want to charge 25 cents a copy. So I left and I had to go to work, but I went and bought ink and I have all this copy for you. And I also can show you, I have 3 years of emails.
Ma'am.
Emails.
Ma'am. I thought we already went through all of this.
I brought it, but I mean.
Wait a minute. I don't care about emails.
Okay.
This is for non-payment rent.
Yes, and I have that. They've been harassing.
I know you told me that. I heard you say that the last time. This is about non-payment. That's all I'm here going to address. If there are separate causes of action that exist because somebody's been harassing somebody, that's a whole different issue. Why didn't you give them the copies so they could review them before we started today?
I had no idea to give them copies. I came to tell you about the copies here, and I have emails reaching out to them. They won't email me back. They won't do anything with. I offered the last 6 months to give them copies. I have them.
How much do you owe?
I don't owe any rent. They're trying to get me for late fees. I have proof they were paid before the late fee date.
I don't think so.
Can I show you?
I don't think so.
I have.
Listen, I should have listened to the tape again because there is no doubt you were going to come in here and tell me this again.
I have it right.
Ma'am, I'm talking, okay? I don't want to be rude, but how much do you owe?
I don't owe any rent.
I don't care about rent. How much do you owe them? Remember, I talked to you about that last time. Math is easy. There's a very easy answer to math questions. Ma'am. The great thing about math is there's only one right answer.
So I have no late fees. I have 0 late.
I don't care about late fees. I want to know.
Oh, for rent. I'm up to date. I'm up to date for rent. They decided
There's more. There's more.
From the rent.
There's more. If you don't pay all of the monthly rental rate.
I did. That's what I'm frustrated. I'm not a lawyer.
You keep interrupting. You did this last time. I'm going to lose my patience. The last thing I want to do up here is lose my patience. Okay? Really. You did the same thing to me last time.
I did not.
I don't want to be interrupted.
My name.
Do I look like the kind of guy that wants to be interrupted?
No.
Ma'am. If you don't pay your rent in full because you owed other late fees, then that keeps accruing. You follow me? Like if you don't pay all your rent in June and they've accumulated late fees, even if you pay your rent by the end of June, you haven't paid the late fees. Therefore, another late fee accrues if you pay what the rent is in July, but don't pay the late fees. How much do you owe them? I don't care if it's in past due rent, costs, or
late fees. They've been doing this 3 years, and I have a trail record. I even contacted David Rudisell last year because they.
You're going to interrupt me every time, aren't you?
No, I don't know how to get this information.
No, you're gonna interrupt me. You're gonna interrupt me, and it doesn't matter what I say or do. You're just gonna keep interrupting me. It's one of these days. I mean, it's gonna be one of these days for me. Because you just don't want to listen, and you didn't listen last time. Listening is a virtue. You follow me? Listening is a virtue. When I listen, and you listen, then we can communicate, but we can't if we're talking over the other person all the time. Are you telling me right now that you owe, now just let me finish the question, that you owe nothing in past due rent, that you owe nothing in late fees, and that you owe nothing in court costs, and that you owe nothing in statutory attorney?
I don't know what statutory means.
$75 they're entitled to when they get a judgment.
October of 2020.
I didn't ask you.
Okay.
I did not ask you about October.
So
We're now into May, believe it or not.
Right, and I have all of this, so I don't know what you want me to show you.
I want you to tell me how much money that you owe them in all of these categories. Add them up. Rent, costs, attorney fees, late fees, add them all up and give me the exact dollar figure that you owe right now.
I would owe.
I don't. It's very simple. Just tell me the month that you owe.
I think $75 was the basic that I owe. And they kept tacking it on and tacking stuff on.
Because you didn't.
They didn't.
Because you didn't pay. When's the last time she paid in full, Ms. Schoen?
Your Honor, I have witnesses here. I've got the bookkeeper. I also have the property manager. So she still has not paid her carrying charges for this month. They were due on the 1st. They still have not been paid.
She's convinced because you're late. This is how well I remember this case.
Whose phone is it? It's got to go out.
She's convinced that she owes nothing for May right now because the late fees, I'm sorry, because the late fee provision doesn't kick in until the 10th. Am I right? That's what you told me last time. Wait, am I right?
I'm sorry, for today? I don't know. You said the 10th. May.
I have a feeling I'm gonna have to put you last because I'm not gonna keep all these other people wait. You told me last time that you don't owe, the rent isn't due till the 10th because there's no late fee provision until the 10th.
It doesn't mean it was paid on the 10th. That was their rules. So there's no late fees. So I paid up to April. Now May is due. I came to court first.
How much do you think she owes? And give me the breakdown.
Yes,
You
Your
didn't
Honor.
follow my directions very well, Ms. Moore.
Your Honor, I have ADHD. I am struggling right now, big time from this. Big time from this. I missed work. I'm having an anxiety attack.
All right, okay. Just calm down. Tell me exactly how you guys calculate the past due rent, and it is past due, even though the late fee provision for May doesn't kick in until the 10th. You understand me?
Yes.
Right? Okay. Tell me how much you owe and how much you think she owes and how you calculate it.
Yes, Your Honor. The total that she owes, and I do have witnesses here as well. The total she owes right now is $775 plus our statutory attorney fees of $179.04. So the way that the carrying charges here, we're with this co-op, the carrying charges apply.
I'm going to make sure I understand. You're saying $775 plus the statutory attorney fee is $75, right?
Just a moment, Your Honor. So the statutory, the filing fee is $70.04 because we requested a second mailing. So it's $70.04 is the filing fee plus a $35 service plea plus the $75 statutory attorney fee is $179.04, Your Honor. Those are our court costs. The amount of arrears in total are $775. When Miss Moore makes a payment, the payment is applied to the oldest balance. So right now she owes $725 in carrying charges and a $50 late fee.
For the month of May?
She owes a partial balance for the month of April in her carrying charges, because when she has made those carrying charges payments, they went to the oldest balance. So she owes a full May plus a portion for April, and then she owes $50 late fee for April. It has not been applied yet for May. Now, I just want to let the court know that when the NSF fee took place in October, my witness here, Miss Linda Farrar, immediately contacted Miss Moore. She immediately sent her a notice. She sent her a letter explaining that an NSF had happened, that the $50 late fee was applying, that a $25 NSF fee was applying, and they gave them for 3 months without late fees. They continually sent her updated notices of the amounts that was owing for 3 entire months. They did not charge any late fees. So Miss Moore, did not satisfy the amount that was owing at that time. And so there were
you think she
several
owes
months.
$179.04 plus $775? Is that true?
It's $775 rounder plus $179.04. That's right. And we're happy to give her 2 weeks to pay that.
So that's $954.04.
That's right, Your Honor.
See, do you understand that, Ms. Moore? Now, I want to just talk to you. Please just listen to me. I remember we talked about the late fee and you said that they didn't give you notice, and I was convinced that they gave you notice. But what they're saying to you is, let's say your rent was $100 a month. If you had late fees accumulated, but you only went and paid $100, that being your monthly rental rate in my example, you still owed late fees that cause you to owe late fees for the month after that, and the month after that, and the month after that, and the month after that. Do you understand that?
I understand the information you're getting from them, and I don't know how to show you they're wrong. I have it. I don't know how to give you this and show it to you. I have copies the last 3 years because the last 3 years they've sued me in court here. The last 3 years they keep suing me. They keep suing me. And I keep emails to prove now, and I have a paper trail. If everything.
When did she stop? When did she go into arrears as it relates to this case, counsel?
She was in arrears officially back in October when the NSF payment. So she's been carrying a balance since October when she submitted a check for funds that she did not have in the bank.
Hang on one second. I'm going to just ask you a question. I interrupted you and I apologize, but how much are your late fees on this case again per month?
So the late fees are $50 a month, and they did not charge them for several months. So the total late fees are right now $200, which is 4 months, but we're actually entitled to 7 months of late fees because she was late for.
They're only charging you $200 instead of $350. And then a large bulk of this is for the May rent, correct?
Yes, the vast majority.
How much is the May rent again?
May carrying charges are $552, and they have not been paid.
So that's $552 plus $200 in late fees. That's $752. Plus you owe, ma'am, $179.04 in costs.
So it's also the 25. I'm sorry.
No, go ahead. And also what?
So it's if we break it down. So if we break it down into arrears based on what she owes for this month. For this month, she owes $550, and then it's $200 for the late fee and $25 for the NSF. So that's $775, Your Honor, plus our statutory cost of $179.04. That's not the accounting method that the cooperative uses because they apply the payments to the oldest balance, like all consumer debts, credit cards.
How much did you come up with then? $956.04 is what I got.
I've got $954.04, Your Honor.
So, Ms. Moore, I want you to listen. Do you understand that? And don't just tell me no to be obstinate. I just want to make sure you understand that when you bounce the check, that you accumulated an NSF check fee of $25, and now you were on the hook for late fees back in October. And even though you may have paid your rent in November, you were still late because you didn't pay the balance owing in October. And they're actually cutting down the late fees, as I understand it, by 3 months. So they're really only charging you for January, February, March, April. How do you get right? You're only charging for $200 in late fees, right?
Yes, Your Honor. We're only charging for November, December, January, and February, essentially. Yeah. So we would be entitled to 7, which would be $350.
But you're not asking for that, right? Right.
No, we're not.
So
we waived those.
They're waiving $150 in late fees. And please don't just tell me, look at this. I'm not your lawyer. And I told you to send that to them and bring it to the court. And you can't answer my question. You just keep saying 0, 0, 0. I don't know anything, right? Go ahead. I'm going to shut my mouth. I'm going to let you talk.
Back October, when I bounced the check, I paid it before the 10th. Okay.
Did she pay I'll interrupt you there. Did she pay the NSF, the money for October before October 10th?
No, she did not, Your Honor.
I didn't think so from last time either.
She absolutely did not, because the NSF payment, if I may respond, Ms. Moore, the NSF payment itself, so she made the payment on October 10th. That was the date that the payment was made. Then it was returned for insufficient funds on the 17th of October. So there's no way that she replenished that by the 10th of October. The 10th of October is the date that the payment bounced itself.
So then once you became late on that, you were late for all the subsequent months. Do you understand that? I want to make sure you understand that. You paid them on the 10th, it bounced. So you didn't really pay them.
So October 31st, when they put a letter in my door on Halloween night, that was the first notice I had. I ran out Friday, came back and paid October's rent. Just so you know.
But you didn't pay the late fee for October. You didn't pay the late fee for October, right?
No.
And you didn't pay the NSF fee for October. Wait.
You're right. I asked it.
And then, so now you were still carrying a balance of $75. Do you understand that?
I was reaching out to
Do you understand that?
Yes, I do.
It was your fault, not theirs. right? It was your fault, not theirs. You bounced a check. We can't bounce checks. It's illegal to write a check when we don't have the money in the account. We know of that, okay? So you bounced a check. Now, how much? So I gotta tell you right off of there, and I'm trying to make you understand this. The rental amount for May is $552, right?
Yes, the carrying charges are $552. I just
Right.
want to say one thing, Your Honor. One of the reasons that we came back was because she claimed at the last hearing that she had no notice of this. And she's now saying that
she did. I was convinced she did. But even so, 552 plus 179.04 in court costs, plus the statutory attorney fee of 75, that comes out to 806.04. Does it not? Am I wrong, counsel?
No, it's 954.04, Your Honor. It's
no, I know that, but that includes 3 months of late fees at least. And if you pay this all before the 10th, you don't have a late fee on the May rent. Do you understand what I'm telling you? Do you agree with me that I'm right? And please don't just say, no, I don't agree with you, to be obstinate with me.
Not trying to.
Okay.
They're not being forthcoming right now.
Okay. What did they lie about?
First one, I didn't get notice and I have emails. I never got a notice from them. They will not email me.
You bounced the check. You bounced the check.
I'm sorry. May I interrupt, Your Honor?
The first occurrence, they waived. So I emailed them over and over again, asking if they would contact me. Then they said my payment was late, and I have proof I paid it.
You bounced the check, right? You bounced the check, right?
Right.
And then you had a late fee because you bounced the check. And an NSF check fee since you bounced the check. That's $75. And all these payments that you made since then, I'm sorry, but they were not timely.
Yeah, I have it right here.
Ma'am. If you prove to me you paid the $75 balance plus the $552 by November 10th.
November 6th. I didn't pay the 75.
I know, because that's why you were behind and they applied the $552.
I did not know until
It was not their fault. It was not their fault.
I have 3 years of.
Ma'am, I don't want to go back to 3 years. This has nothing to do with 3 years ago. Ma'am, we're not going back 3 years. There's no reason to go back 3 years.
I have a paper trail of them doing this to me, charging me for late fees, and it wasn't late. I have checks from 2000. I have stuff I have been keeping because of them.
He told me, and she is an officer of the court. She told me that this all started to occur in October. Is that true or false, Ms. Schoen? She was up to date until she bounced the check that she delivered on October the 10th. Is that true or false?
So we had a zero balance. She had a zero balance on October. She had a zero balance for September. And then her carrying charges became due in October. So she did have a zero balance. I'd just like to say, Your Honor, Ms. Moore keeps changing her story. She says she didn't receive notice, but then she said, I got notice on Halloween.
I remember I found that she had notice. Ma'am.
She just stated that she has.
Ma'am. Do you realize we're fighting over 7 months or 6 months of late fees?
Yes.
And they waived 3 of them?
I'd rather go to trial because
You don't get a trial unless I find there's no triable issue here, ma'am.
3 years of them targeting.
You don't get a trial unless I find there's a triable issue, and I can't figure out how there is one here. Between last time and this time, I am convinced that they started to add the late fees when you bounced the check, which then gave them an NSF fee check of $25 entitlement plus the $50 in late fees. And then you might have paid your rent of $552 or $56 every month timely, but you didn't pay the late fees and you didn't pay the NSF fees. What were you disputing? Why were you disputing it when you bounced the check?
Their first occurrence, that was my first occurrence. And since 2019, I own my own house for 24 years. I'm single going through, I mean, I'm not, my husband, I'm legally married. I'm going through a divorce. I am doing this on my own.
Ma'am, I'm going to try to help you right now. If you need more time, I can give you more time.
I would love more time.
How much time do you need to pay this?
I would love more time for you to look at this paper.
I don't need to look at anything, ma'am. I've listened. I listened to you before and I listen to you now. And one thing is clear. You bounced the check.
I did bounce the check.
And you didn't pay the NSF fee of $25, and you didn't pay the late fee.
All my emails.
I don't care about your emails. I'll swear you to an oath. Do you want me to swear you to an oath? And you can tell me if you ever got this balance back to zero, taking them at their word that every month they were charging you late fees because you owed them $75.
They were charging on late fees.
No, they were.
I didn't know anything about a bounce check and their rules and regulations. I even got the original rule.
Do you realize you're arguing over about 150 or ma'am? Ma'am? Do you realize you're arguing over $200 that you cost?
It's more than that, Your Honor.
No, it's not.
This is the third year in a row they've done this to me. And then they did it to me last
Well, then pay your bills on time.
This wasn't the bills. I've never bounced a check. If you saw the pattern and history of this.
I told you to tell me how much you owe when you refused to do that. I asked you 3 times the other day. I said to calculate it before you came back. And you keep interrupting. What? You think you owe 0, right?
If the first occurrence, like they say, it's waived, this is my first occurrence since 2019.
Does it say in the lease that if you bounce a check the first time, it's okay?
The first occurrence.
Do they say that in the lease somewhere where if you bounce a check, it's okay?
They sent me an email.
I don't think you're listening very well. You want to fight with them.
I don't want to fight. I want you. I wish you could see all the stuff that
Ma'am, this is for non-payment of rent.
I paid.
This is for no, you did not pay.
Do you know they don't even send notices?
Do you not, are you not, am I doing?
Or can I request, I asked if I can pay online, so I had a paper trail, because right now I'm recording.
Can they pay it online?
They told me no.
We can,
Pay it by check. You got a better paper trail.
We'd like certified funds, Your Honor, since she has a history of bouncing checks.
That's one.
Ma'am, how many times has she bounced a check now, Ms. Schoen? Be careful with this. You're saying she has a history. She's saying it's one.
She does have a history. She's acknowledged that she has done it. I don't know if she's done it many times beyond that.
Well, she does from October, but are you aware of other bounce checks?
I'm not, but I have our bookkeeper here.
Who's your bookkeeper?
Her name is Linda Farrar.
Ms. Farrar,
she's here.
Ms. Farrar, raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you give in these proceedings be the whole true self you got.
I do, Your Honor.
How many bounce checks has Ms. Moore submitted to the apartment complex, say in the last 3 years?
You know, I don't have that information handy. We got a new computer system back at the beginning part of last year, so I would have to go back in archives and look. I don't have that, Your Honor.
Some of it, they won't give me my whole file, but I can get it.
Hey, hang on. What do you want me to look at?
This has the dates and stuff, and it has no bounce check.
Okay.
Nothing.
I'm gonna believe you. I'm gonna believe you. Okay? I'm gonna believe you. Now, I just want to make sure I have a good understanding as to what you think is owed. And remember, we're including May rent now. You understand that, right? Ms. Moore?
My rent every month. My
This rent that you owe for May.
Oh, I owe May, yes. I came to court first to see.
Yeah, so that was for $552, right, Ms. Schoen?
Yes. So her carrying charges are $552, but because of the non-payment of the late fees and the NSF fee, and the way that the payments are applied to the oldest balance, she actually owes $725 in carrying charges.
$752. Right?
$725 in carrying charges, and then the 50 is for the late fee. So $725 is what she owes in carrying charges plus the 50 late fee. Takes us to
I just want to figure out without late fees. Right now, without late fees, shows $552 plus $179.04 plus $75, right?
plus the $25 NSF fee.
Plus, okay, I forgot that. My mistake. So it should be without any other late fees, $831.04, right?
That sounds right.
552 plus 179.04 plus 75 equals 806.04. And you got a $25 NSF fee, and that makes it to 831.04. And that's without any late fees.
That sounds right, Your Honor, without the late fees, although we do argue that we're entitled to them, and we did forgive almost half of the late fees already.
Cut this short. I'm going to cut this short because I am going to cut this short. Do you see how you at least owe $831.04?
No.
I'm going to order another $150 in late fees, and that makes the total. Would you ask me for
$954.04, Your Honor.
Well, I'm going to give you $100. $931.04. Judgment for plaintiff, $931.04, and I will work with you, Ms. Moore. I will work with you in terms of payment. Can you pay this?
No, I cannot. I worked in the first year for 6 weeks.
Okay, just remember though that your payment's due on the 10th. Tell me a legitimate time when you can pay this.
Today the rent, 552.
No, you're going to pay all of it, or you're going to get kicked out.
It's okay.
You're going to pay $931.04. Well, tell me when you can pay $931.04, and I'll work with you.
I don't know. I can give you the 552 today. I don't know about anything else.
Well, you're going to have to give me a date, ma'am.
Well, so 552. Well, I don't know what the difference is that I would owe.
I'll tell you in a second.
I'm not able to
Wait. I don't see how you can owe less than that, man. I said $931.04. Did I not, Ms. Schoen?
You did, Your Honor, and we're happy
So I'm only
to give
giving them $100 of late fees. That's probably too kind on my part. They're entitled to a lot more. Sounds like they're entitled to 7 months or 350. But if you owe $931.04 and you pay $552, that means
I'm showing $379.04, Your Honor, would be the difference.
$379.04 that you would owe. Okay? And that will take care of all your rent and everything else up through the writ date. Now, I can extend the writ date for you. Okay? Tell me when you can come up with the other $379.04.
Plus my rent for next month. I have to factor in like a month.
I can't do that.
A month for 3.
Here's what I'll do. Counsel, the order of judgment should be for that amount. If defendant pays $552 by May the 14th, writ date extended until May the 28th. So you've got 24 days to pay. But then you're still going to owe June rent. But you have to stay up on that and pay that. I would pay it by the 1st. I'd figure out a way to pay it by the 1st, and then you don't need to worry about it.
May I ask permission? I don't know if I ask this. Because the trust between the office and myself, David Russo is on the board. I need a third party that I'm able to contact.
Dave Rudisell.
Yeah, I contacted him last summer.
He's the police officer, right? Ex-police officer. He's the ex-police officer from Riverview.
Yes.
He's a trustworthy guy.
I had to go to him last year because they pulled something shady with the last year.
Now, can I tell you something? You're not near as old as I am, but this world is short.
It is.
We're very short for this time.
It is.
Why don't you just calm down, pay your rent when you're supposed to? I'm not getting into these other issues. This was only over non-payment of rent.
It's been.
But I think you're fighting with them unnecessarily. I think I probably, if I gave a disservice to anybody, it was to them. I really do.
Should I leave this?
Did you hear what I said? No, I'm done with this. There's no triable issue here, ma'am. There is no triable issue, but you're not seeing the forest for the trees because you want to argue with them. Now, these issues are not before the court. And all I'm trying to do right now is figure out whether there's a triable issue. And I've easily concluded, no, there's not. They could argue, they should appeal me, frankly. They should appeal me because I've been too kind to you, and you don't have a defense based on everything that I've heard. Now let's terminate this conversation, okay? Really and truly, I'm cutting a break. You paid that money by the 14th, you paid the rest by the 28th, and everybody's happy and back to square one. Then just pay by the 1st every month. Don't look at it like your rent isn't due till the 10th. Don't look at it that way.
Oh, I know.
I mean, that's what the contract says. That it doesn't mean the rent isn't due till the 10th. It means rent is due on the 1st. But if you pay by the 10th, there's no late fee. But that's it. I'm very confident I've done the right thing from your standpoint. I'm not so clear if I have with them.
Your Honor, we would just object. We'd object to the.
I know. It's okay. You don't need to object. You guys can appeal. I get it.
Can I just very briefly give my objection?
Why? You can appeal. The record's clear. You want me to give $200 a month in rent. You think you're entitled to $350.
Your Honor,
you guys can go up and appeal. It's okay.
Your Honor.
I'm not going to argue with anybody, ladies and gentlemen. I'm sorry. I'm not always right. I try to be, but I'm not arguing with anybody. Okay, so if the appellate court needs me to tell them why I did what I did, well, I'm probably going to have to say maybe I shouldn't have done that. But that's it, Ms. Schoen. Thank you very much. Have a good day. Submit your judgment today. Thank you.
Thank you, Your Honor.
Okay, and we are on the record in the matter the state of Michigan versus Donovan Martin, 26564. And detective, if you can please state your name for the record.
Sergeant Devin Geiger, Wyandotte Police Department.
All right, thank you. And please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. All right. And so, detective, you may proceed.
On May 1st, 2026, approximately 12:57, Officer Guzman on patrol and fully marked unit 74 traveling southbound 4th Street near Pine Street. Vehicle is fully marked with Wyandotte decals and lettering, and she's also in a full police uniform with insignia and patch. While on patrol, she noticed a white Ford Fusion merged from lane 3 into lane 2 without using a turn signal. She also noted that the license plate cover on the vehicle made the plate ineligible to read. Due to these circumstances, she attempted to make a traffic stop with emergency lights on. The vehicle continued to travel, not pulling over or getting into the right lane, continuing to go the speed limit. At this point, Officer Guzman radioed dispatch that the vehicle appeared to be doing a slow stop or slow roll as they were still traveling southbound, approaching Leroy. The vehicle continued to travel southbound on 4th Street, approaching Quarry Road, when she noticed the Fusion to accelerate to speeds of 60 miles per hour, despite being in a 45 mile per hour zone. It was at this time that Officer Guzman recognized that the vehicle was attempting to elude her, and then activated her sirens as well. The vehicle continued southbound 4th Street until it would turn on a westbound on the Pennsylvania Road, completely disregarding the red signal despite heavy traffic. The Fusion continued to travel westbound Pennsylvania Road, reaching speeds excess of 77 miles per hour. The Fusion then turned northbound on McCann Street from westbound Pennsylvania, reaching top speed of 60 miles per hour in a 25 mile per hour zone while passing both Allen Elementary School and Southgate High School. The vehicle continued to drive recklessly throughout the pursuit, disregarding all traffic control devices, going off-road and driving high rates of speed. The chase eventually led to 16500 Quarry Road, which is Southgate Apartments. It was at that point the vehicle is reported to have purposely crashed into the lobby doors of the building, where the occupant exited the vehicle and fled on foot immediately. After crashing into the building, officers gave pursuit. At this point, that Sergeant Gardaki, who was also involved in the chase, began running after the suspect and announced or gave orders for the suspect to stop. The verbal commands were disregarded. Sergeant Gardaki then deployed his taser, which partially helped stop the suspect. He had to be tackled to the ground. At this point, he actively resisted, struggled with the officers. Officer Guzman also had to deploy her taser at some point. Officer Gardaki was actually struck with a taser probe during this process, during the struggle. At this point, the defendant, identified as Donovan Joseph Martin, was taken into custody, handcuffed, and then arrested. And he does have a expired license, Your Honor, and that's it.
Okay, upon examination of the complaining witness, the court does find that the offense charged were committed and that there's probable cause to believe the defendant committed those offenses. And counsel, your appearance, please.
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Donovan Martin.
Mr. Martin, your name for the record, please.
Donovan Martin.
Okay, counsel, as to arraignment.
Yes, Your Honor. At this time, we are prepared to waive a formal reading, and my client stands mute.
All right, the court will waive the formal reading. Sir, you do have the right to have an attorney. If you are unable to afford one, you may have one appointed to represent you. And you did, in fact, have an opportunity to speak to an attorney today. Is that correct?
Yes, ma'am.
All right. The court has also signed the petition in order for appointing an attorney for felony matters. And, sir, you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, ma'am.
The court's going to enter a plea of not guilty on your behalf. We will schedule this matter for probable cause conference on May 14th. 10:45. At 10:45 a.m. And counsel, as to bond.
Yes, Your Honor. I would like you to know that Mr. Martin's currently residing in Southgate. He's not currently on probation or parole. He has no other pending matters that we're aware of. And after speaking with Mr. Martin at length this morning, he did assure me he would be appearing at all future court dates. And he does understand the importance of doing so. I would just ask that all that be taken into account.
All right. So, Mr. Martin, where do you work?
I'm not working at the moment.
When's the last time you were employed, sir?
About a month and a half ago.
And from where were you employed?
I was a server at Oga's Kitchen, Lathrop Village. I had another job lined up, but then all of this happened, so I haven't been able to call or do anything.
When did you have the jobs lined up, sir? Because this just happened Friday.
Like 2 weeks ago. I was supposed to schedule an interview for a new job, but I never made the call.
Oh. All right. And sir, are you currently on probation or parole anywhere?
No.
Not at all.
Not that I know of, no.
Okay. What happened with your matter out of Farmington Hills? January of 23, it shows you were bound over to circuit court for felony assault with intended murder or commit great bodily harm less than murder and felony assault with a dangerous weapon. What happened with that, sir?
I told my attorney that I did do a failure to appear on that, and I was just trying to find an attorney to help me with that case. That case is against my boyfriend, who I am still currently with. So I just was trying to figure that out.
Well, sir, it appears as though you failed to appear for a probable cause conference or a pretrial. I don't know if those conditions were amended at circuit court, but potentially you're not even supposed to have contact with your boyfriend / victim in the matter. So there's that concern, sir. And it looks as though you have other failure to appears. Probation violation, for malicious destruction of property, also out of Farmington Hills.
That was the only failure to appear that I was aware of that I had told my Mr. Westmoreland about this morning.
Nope, there's a second one, sir. You're on probation for malicious destruction of property. And it shows that you have failed to appear in that matter, which appears to be from 2022. Who was the victim in that matter, sir?
John Bell.
Is that the same victim in the other matter you're just stating?
Correct.
Do you have any? Oh, and Mr. Bell was with you in the vehicle?
For this situation?
Yes,
No, he was not.
he was not. Detective, would you like to address bond?
I have great concerns for this case, Your Honor. Multiple lives were at risk during this chase, going through red lights, going through stop signs, passing two schools that were in session, disregarding multiple traffic control devices, then crashing a vehicle into a lobby, nearly striking a vehicle that was occupied. And one of our officers was struck with a probe during this incident. With the warrants from 2022 or 2023, it was great bodily harm. I just concern for the public. So I'd ask for at least 100,000, 10%, and a GPS tether since the warrants are at least, it looks like 3 years old. So not to operate a motor vehicle, no weapon.
Okay, thank you. So, sir, is Mr. Bell a Wayne County Sheriff's deputy?
Yes, ma'am, he is.
Yes. Okay. And so that seems to be why his name is in here, because apparently he pulled up on scene.
Yeah, he pulled up in a separate vehicle. He was in the car with me.
Yes, I see that. Well, the court has significant concerns for the safety of the public as it relates to Mr. Martin and his actions that bring him before the court. Significant concerns. Not only are the allegations that Mr. Martin was driving at excessive speeds in residential areas and school areas, however, it appears as though there's continued concern based upon the allegations that Mr. Martin drove into the apartment building, and then even from that attempted to leave as well. Mr. Martin also, based upon his the charge that he's currently on a warrant for assault with intent to create bodily harm less than murder, the court also has significant concerns. So what this court's going to do is this court's going to find that a $75,000 cash 10% or surety bond. I'm sorry, no, there's no 10% cash bond. In the event Mr. Martin does post bond, Mr. Martin is not to operate a motor vehicle at all, even if his license is no longer expired. Not to be released without GPS tether to the Wayne County Jail. Not to have access to any firearms or weapons. Do you have any of those, sir?
No, ma'am.
Do you have access to any of those, sir?
No, ma'am.
Do you and Mr. Bell reside together?
No.
You're not to possess or consume any alcohol or drugs that are not prescribed. And we will see you back on May 14th.
Thank you, Judge.
Thank you. Have a good day. City of Riverview versus Jenna Chittum, 26365. And counsel, if you can just keep your volume up, please, when you're speaking. Thank you.
Yes, no longer. Attorney Albert Sala, PA 3929, on behalf of Jenna Chittum, who is present to my right. State your name for the record, please.
Jenna Chittum. All right, good morning. And today is the date scheduled in this matter for the arraignment and the pretrial. And counsel, do you have an opportunity? I'm sorry, as to the arraignment.
Yes, Your Honor. Today, as the arraignment, my client wants to waive a formal recharge of remain mute and will request that social be acted at this time.
Okay. The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then as to the pretrial, counsel.
Thank you. Pretrial matter with prosecutor's office and come to a resolution to amend the misdemeanor charge down to an unlicensed person to drive as opposed to the driver license suspended. And we were able to reduce the no proof of insurance down to a blockading, or I'm sorry, the double parking. And my client wants to avail herself to that offer.
Okay. And what's the current status of your license, ma'am?
It's still currently suspended.
Okay. Your attorney worked out a really good deal for you, ma'am. Well, actually, you're revoked. Not even suspended, but revoked.
My apologies, yes.
Okay, ma'am, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
And you heard the extremely generous plea that your attorney was able to work out, correct?
Yes.
And as to the amended charge of allow an unlicensed driver to drive, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And as to the double parking, how do you plead? Responsible or not responsible?
Responsible.
And you understand all the rights that you've gone over, correct?
Yes.
And you understand that by entering into this plea that you'll be waiving some of those rights.
Yes.
Do you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues?
No.
Counsel, if you can please voir dire your client.
Yes, Your Honor, thank you. Jenna, on the date of, I'm going to take you back to the date of March 14, 2026, in the city of Riverview, when you're driving a 2018 Dodge Charger.
Yes.
And at that time and date, did you have a valid license?
No.
So you were driving that vehicle anyway?
Yeah.
And you just speak up, ma'am, please.
Yes.
And on that date and time, did you have valid insurance?
No.
Did a car for you at that time?
Yes.
Or she done the line citation in this case?
Yeah.
I'm sorry?
Yes.
So satisfied, Judge?
All right, the court is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charges, dismiss the original charges per the plea agreement. And counsel, you're asking for immediate sentencing?
Yes, I would ask for that, Judge. Thank you.
Okay, what would you like me to know?
Well, Judge, she's a young lady. She's made some mistakes. She's in the proper courses, and she's doing everything she can to get her life back on track, particularly this license. She's not currently in school. She intends to be enrolled in school by this summer or this summer. By the fall, she's actively looking for work during the summer as well. Entering into this plea would be highly beneficial for her because it would allow her to just put this mishap in the past and allow her to move forward with her life. And for those reasons, Your Honor, we'd ask you to take those things into consideration for sentencing.
How'd you get here today?
My mom.
Where's your mom?
My mom's out in the chairs out there with me.
Where do you work?
I don't currently work. I'm thinking about getting a job back where I used to serve at.
Which was?
Restaurant.
Okay.
Right now.
So, ma'am, what are you doing? You're not working? You're not going to school?
So, I wasn't able to go to college this spring semester, due to my sobriety court, but I'm moving on to the last phase of my sobriety court, and I am enrolled in summer classes, and I will be starting summer classes as of May 19th.
Bless you. Okay, very good. Okay, so sobriety court. I was unaware that you're in sobriety court. That would have been
It's for an underlying probation matter out of 19th district.
No, I understand that, but it would be helpful for me to know that she's in sobriety court.
You're absolutely right.
So do you not have your license through the sobriety court?
No, I do not.
Are you not eligible to have your license through the sobriety court?
No, I should be eligible to get my license back as of the start of 2027.
Okay. So tell me, ma'am, you know all that. So why in the world, there's no talking in court? There's no talking in court. Why in the world are you driving?
I know. And I do not plan on doing that again.
That's great, but you're not answering my question. Why were you driving on March 14th?
It was just to go down the street to the gym, and I should have never done so.
Where do you go to the gym?
Planet Fitness.
So why didn't you just walk to the gym?
And
or take a bike?
I should have.
Or a ride share or get a ride?
Your Honor, I think she would say, and I think we'd all agree that it was a severe lapse in judgment on her part. She's taken it very seriously. She's made representations to me that she's taken it seriously and that she wants to address the underlying probation matter so that she can successfully complete that and then get her license and go forward with her life. She is a very young lady. She had her whole life ahead of her. I think she understands the severity of what she's done.
Well, I would hope so, but I also have concerns that you're not even 21 yet.
No, she's not, Your Honor.
And your license is revoked. For 2 or more substance use convictions. Your prior driving while license expired. Was that a reduction for driving while suspended in the court?
I think it was because I didn't have the paper upon being pulled over.
But wait a minute. I'm showing that you had a sobriety court restricted license. And then it was revoked effective February 5th. Did something happen, counsel, while your client was on her restricted license through the treatment court?
I'm unsure. Could I review what you're reviewing? Is that just the MSP report?
This is just the Secretary of State. Ma'am, how many alcohol-related convictions do you have on your record?
Sorry, Your Honor. Can you repeat the question?
How many alcohol-related driving convictions do you have? 2 or 3?
It was 3, and the first 2 were from when I was 17, and then the last one is what I'm doing right now.
Okay. So when did you begin your treatment court in the 19th District Court?
As of, I want to say June of 2025.
Okay. So what I'm reading is that your client's license was revoked as a result of that plea. And that was effective July 16th of 2025. However, it was amended to sobriety court restrictions on October 10th of 2025. Then it shows October 10th of 25 to February 5th of 26. And then goes on to indicate sanction after it gives all the restrictions. Sobriety court restricted license amended due to circuit court ruling on February 5th of 2026. Shall not drive a vehicle requiring a commercial driver's license, may only operate vehicle equipped with breath alcohol ignition interlock device to and from residence, place of and during employment, treatment and support group meetings, regularly scheduled treatment for serious medical conditions, probation, all of that. Violation of order will reinstate original action.
Your Honor, I believe what occurred on that date was, there was an interlock device. She failed it.
She what?
She violated.
Okay, so that's why her license is revoked now. Okay, because knowing that she's in treatment court would tell me that she would have a license, but she did. Okay.
Your Honor, she spent 30 days in jail as a result of that violation, is what she's telling me.
Okay. Was that violation because you didn't have an interlock or because you consumed alcohol?
I consumed alcohol and ruined the device.
Okay, all right. That'll explain why it'd be the 30 days jail. Okay. The court's going to order a $200 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $525. And so, what is your proposal for payments?
She's here today. Her mom's here today. They're prepared to pay today.
Okay.
They want to just take this on the head and move on.
Okay. All right. Stop at the window. Somebody will be with you shortly.
Thank you.
I don't see you. All right. Thank you. You as well. All right. We're on the record in the matter of the city of Riverview versus Xavier Downey, 251534.
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Mr. Downey. Mr. Downey, would you please unmute and state your name for the record?
Yes, ma'am. My name is Xavier Downey.
All right. Good morning. And so this matter is scheduled for an arraignment pretrial. Mr. Downey was originally scheduled for January 5th, where she failed to appear. The court issued a warrant and your client's now in custody at Wayne County Jail. And as a result, is now having this matter scheduled for the arraignment of pretrial. And so counsel asks the arraignment.
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
All right. Or we'll waive the formal reading. Enter a plea of not guilty for purpose of the arraignment. And then ask the pretrial counsel.
Yes, Your Honor. At this time, the city attorney has offered to dismiss 1 count of larceny, 1 count of malicious mischief, and 2 counts of breaking and entering. And in return, Mr. Downey is prepared to plead guilty to 1 count of larceny, 1 count of malicious mischief, and 2 counts of breaking and entering.
Okay, so am I just picking which counts or are there any specific counts?
They're all the same, Your Honor.
Or are there different victims?
I don't, that I'm not sure.
Okay, well, one named victim would be Daniel Vert. Then, and that's regarding a pistol magazine. And then the other individual is Jacob Wise regarding ownership vehicles for a truck. Then the other individual again is Daniel Vert regarding entering into the victim's truck. Jacob Wise again. Entering into the truck. Nicholas Flint. Entering into the vehicle, Tracy Denigian. Entering into the vehicle, David Pippin. Entry into the vehicle, and then Isa Adeline. Entry into the tampering in with the vehicle. So that's what I was asking counsel because
Right.
there's different victims. So what I'm going to do is have you speak to Mr. Johnson regarding that so we can just clarify which matters are being dismissed and which ones we're proceeding on. Okay. So then we can recall this matter. Okay, so if somebody can to Mr. Johnson. Thank you. Okay, and then all right, so he's speaking to Mr. Okay, so we're gonna that's okay, we'll just call it back when he's got on the record. Let's recall the matter of the city of Riverview versus Xavier Downey 251534.
Attorney Corey Westmoreland appearing on behalf of Mr. Downey. Mr. Downey, would you please unmute yourself and state your full name for the record?
Yes, ma'am. My name is Xavier Downey.
Okay, well, counsel?
Yes, Your Honor. At this time, I would just ask to have Mr. Downey arraigned today. Per the arraignment, we are prepared to waive the formal reading. My client stands mute.
Yes, I've done that. Yes, sorry, that's a pretrial counsel. I already waived. We already did the waiver of the arraignment.
And I would just ask that the pretrial be set for next Monday.
All right, so we will set for pretrial on May 11th. 9:30 a.m. As to bond.
Yes, Your Honor. Mr. Downey had been in custody, I believe, since roughly April 17th. I would like you to know he is gainfully employed. He's working at Little Caesars Arena whenever there's sporting events, concerts. He's in charge of helping get everything up and running for whatever specific event is going on that day. I do believe he does have a matter out of Canton that he does have a personal bond for. He's just awaiting a tether. He assured me he would be appearing. He knows he needs to take care of this, get this matter behind him for Salt as well. I would just ask that all that be taken to assessing bond.
Okay, sir. Why didn't you show up for court here?
Well, really, I got into it with my grandma at the original address that is posted for me where I live at 28 West Seacott, and she kicked me out. And I'm gonna be real with you. When I first got here and I said I had a warrant for Riverview, like I knew it was gonna be posted, but I never knew like it actually been posted like that time. Like when I called and stuff, because me and my grandma are close now. We got back close. And when I talked to her, she was like, "Yeah, you did have something in the mail about it." And then I was like, "Why didn't you tell me?" And she was like, I don't know why she didn't tell me. She didn't even have an excuse why she didn't tell me. And I never even knew I had the court on the January 5th. But I didn't have no problem showing up. River Rouge is like 15 minutes from Riverview, and you probably know that too, because you're like 2 cities away.
Okay, well, sir, sorry, you knew this matter was out there, correct?
Yes, but they said they're gonna send one. They like when I first recognized that I was gonna get a warrant, like they said they're gonna send one before they took me to Cannon. So I didn't know when it was sent out. Like I never got the
All
date.
right,
I
so
never got.
did you, what steps did you take, sir, to find out if it was happening?
It was when I got here, they said I had another warrant. And I
Right.
didn't know what that warrant was for. And then they that's when they came in, they give you the little paper and then they told me what the warrant was for and I found out it was for Riverview.
Yes, but sir, I think you're missing my question.
Oh, what was your question, ma'am?
What steps did you take to contact the court to find out when you had a court date?
I didn't take no steps, ma'am. I was clueless on it. But only thing I did know is I had a ticket for Wyandotte. I remember she did tell me that I had a ticket for Wyandotte that I had to pay, and I was gonna pay. I was working on paying that.
And so you're back at the address of record, sir?
Yes, I am. Me and my grandma got close again.
Okay, and what is your matter in, that you're on probation for? I'm sorry, out on bond for? From the Canton?
For basically the same thing, but I also got obstructing a police officer.
So larceny and, entering without permission
No,
and
no.
obstructing?
No, I just got larceny and then obstructing. No, it doesn't look good.
Well, it doesn't, especially, sir, since you're out on, you have a pending matter and now you're charged with the exact same thing. You're correct. That does not look good.
Yeah. But that was around the time I stopped, man. I'm trying to get my life together. I'm trying to go back to school.
Sir, when were you arrested in Canton?
If I'm not mistaken, it was around the time I got sometime in September of 2025. I don't know the date exactly. I think if I'm not mistaken, it was the 18th of September.
So you were arrested in Canton on the 18th of September.
Yes.
And
No,
this matter was October 9th.
I was arrested for Cannon on September 18th. And then
Right. And then you didn't go to court for that matter because it seems as though you're just now handling that matter in Canton.
No, I did go to court, but then I went to go see my probation officer, but then my ride, me and my stepmom, again, she just didn't want to take me out there. She just didn't want to.
So
And
you're on probation. Excuse me,
I did
you're on
contact
probation.
Cannon about it. That's
Sir?
why I got my bad. Sorry.
Hold on. So you're on probation in the 35th District Court.
Yes, ma'am.
Okay. Do you have any other warrants, sir?
No, ma'am. I'm just trying to get all these out with.
Have you ever failed to appear in any other matter?
I did one time. That's because I didn't have a ride to Cannon, but like I said, I got that cleared out.
Okay. Well, given that you have a history of failing to appear, you're on probation for the same matter, which the court will note you were not on probation at the time this occurred, but you were on bond at the time this occurred. The court wants to ensure the safety of the community and wants to ensure you're going to be appearing in court. So the court's going to order a $750 bond with the following bond conditions. You are not to have any contact with the victims in this matter, to already name their names. You're not to enter onto Mulberry Avenue, Old Town Drive, or Brookline Street in the city of Riverview. You're not to possess or have access to firearms or weapons, and you are not to be released on a GPS tether through the Wayne County Jail.
Wait, so I'm not getting released on that?
I understand that you have a GPS tether ordered out of the 35th District Court. I'm not suggesting that you would have two tethers, sir. You would have an order for a tether by two courts.
Wait, so I don't get no 10%?
No, sir. What the court's doing is instead of doing $7,500, 10%, straight $750 bond.
Yes, ma'am.
All right, we'll see you back Monday. Have a good day.
Thank you.
Thank you. All right, and so we're on the record in the matter of the city of Riverview versus Nathan Curry, 26204.
Yeah, who does his hand up?
Good afternoon.
Good afternoon, Richard T. Serrano, P. 828. Your Honor, I was to appear today as MIDC counsel on behalf of my client who appears today as I do appear. Your Honor, I'm standing here at the defense counsel table for the reason that I have a motion to orally withdraw from the matter. I'll state.
Okay, Mr. Curry, your name for the record, please.
Nathan Robert Curry.
Okay, so today is the date scheduled for sentencing on Mr. Curry's plea as charged to improper use of telecommunication devices. And yes, Mr. Serrano, you are the attorney of record, and you stated you want to make an oral motion to withdraw.
That's correct, Your Honor. Your Honor, if I may, we did appear last time, as the court is aware. My client knowingly, voluntarily, accurately, understandably made a voluntary plea, as the court has stated. I've reviewed the pre-sentence report, but I cannot address it because in the interim period, while this case was pending, my client and I have had discussions, both live. He, I believe, waived his attorney-client privilege long ago because at the first pretrial, he insisted that he have the gentleman with him today present in court, present in the office while we were talking voluntarily. I told him that he would be waiving his attorney-client privilege if he has someone else in the room. He had no problem with that. Neither did I. Many clients feel they need support, so oftentimes I have no objection to that. What followed subsequently, my client sent me a 5-page typewritten manifesto. I'll call it that because it contained things in there that one of the reasons my client later told me that I was ineffective assistance of counsel is because I did not share this 5-page typewritten document with the court, meaning Your Honor. And I told him this would entirely be inappropriate at the time. We were still in pretrial. That letter contained things that he believed perhaps were exculpatory. But as a trained attorney, I pointed out some things that could be construed as inculpatory. And I told him I'm not going to submit this to the court. Now that he's here for sentencing, if he desires the court to read that, there is much in it that has no relevance to this court. He cites the Constitution, the Bill of Rights. Broadly, some of them may be applicable to these charges. But when he got on to citing the Monroe Doctrine and extolling that the Bible frowns upon same-sex marriages and alluding to subjects that have entirely nothing to do with this case, other than the conversations he may have had why he is here with the subjects that the others subjected the others to phone harassment. Similar, when I read the context of those, they sounded very similar to what he was writing to me in his manifesto. So with that, Your Honor, I tolerated it. I told him what I could, tried to help him. As the court knows, we took the plea. And then he had a habit during the pendency to call me between the hours of 4:30 a.m. and 6:30 a.m.
Right, really, Your Honor.
Excuse me, just one moment.
And I have no problem with that. I've been a lawyer going on 45 years now, Your Honor, both as a prosecutor and defense counsel. I take withdrawing from cases very seriously. Probably less than 1% of the cases that I've entire career handled in the criminal practice field, I've had to withdraw for various reasons. This, I believe, presents an extreme, very important reason why I must withdraw, in that I received a phone call about 5:30 a.m. in mid-April. I have a transcript on my cell phone if the court wants to hear it. Basically, I'll summarize it. It was telling me that if I understood what effective assistance of counsel meant, and you were not that. He said I was merely, quote, covering my ass, and quote, "You are an ass." And furthermore, the thing that really set it over, Your Honor, again, I'm tolerant of clients charged with criminal offenses. They're sensitive. They all need individual attention. Each case is different on its facts, just like each client is different on their personalities. But what really set it over for was the next statement where he said that I was in collusion with the prosecuting attorney and not on his side, but doing what the prosecutor wanted. Your Honor, I think the court will take judicial notice that the attorney-client privilege, the first element has to be trust between the attorney and client. When that is eroded and client and attorney are no longer able to be on the same page and no longer trust each other's various positions, then under the Michigan Rules of Professional Conduct, Your Honor, simply MRPC 1.16, pertaining to the declining or terminating representation, I will point out parent 6 says it's pretty much a catch-all. But again, Your Honor, I don't need any Michigan responsibility codes to tell me that when the client says that I'm in collusion and he said you're treasonous, things of that nature. I no longer can represent him, Your Honor, and I don't think that the state bar would want me to in this situation. So with that, Your Honor, I asked the court permission to withdraw. I've told him, and just so he would not be caught off guard, a couple of weeks ago, I sent him a letter that he's received stating what I plan to do, what his options were today, be it represent himself, hire his own private attorney, or ask the court for appointed counsel other than me. So he has his options. I don't think his case is going to be prejudiced by my withdrawal. Certainly, it's his idea to not want me. But with that, Your Honor, we're leaving the court's discretion, and I hope you allow me to withdraw today.
All right. Thank you. And Mr. Curry, do you have any objection to Mr. Serrano withdrawing?
No, I have no objections.
All right. Based upon what counsel has placed on the record as an officer of the court would agree that Mr. Serrano cannot proceed as Mr. Curry's attorney based upon MRPC 1.16 parameters, as well as what's been placed on the record as far as the breakdown of the attorney-client relationships. The court's going to grant Mr. Serrano's oral motion to withdraw from representing Mr. Curry. And Mr. Curry, are you asking for a new attorney to represent you for sentencing?
Your Honor, I've already entered a plea of guilty, and I've been given conditions of my bond in relation to judgment on probation.
Well, sir, bond and probation are two different things.
Okay, I'm not aware of it.
Bond is supervision, is court supervision while your matter is pending. Probation is something if this court were to order probation, which I don't know if I would or would not. If this court were to order probation, you would have certain conditions to complete after, but you're still under supervision, but it's not technically, it's not during the pendency of your matter.
As I testified in the pretrial, simply the messages left at Rotary Community High School were primarily about the Bill of Rights, and I understand that that's a high level case. I understand that it's a very touchy situation given the conditions in our country. I also understand that most people are not aware of the inherent connection between the word "we" and sexuality as it pertains to the words "we, the people of the United States."
Sir, just a moment. What does "we" and sexuality have anything to do with this case?
Primarily, Your Honor, I don't know if it's appropriate to discuss it, but if you underline the verb created in the first sentence of the Bible, you should succumb to the fact that only one type of sexuality coincides with the verb created in God, and that's heterosexuality. And in lieu of my first clause,
first right of the Bill of Rights, rights, it does pertain to mental illness as well. And I really feel like this is, this is a crutch that people have with me, that I have a mental illness. And I have gone through something at University of Michigan in Ann Arbor. And to me, it's a higher level case. To not be able to speak freely with educators about the Bill of Rights is, in my opinion, like he said, treason.
Well, sir, you certainly are entitled to your opinion. Excessive contact and excessive calling is where the issue comes in. So what I'm going to do is I'm going to not conduct the sentencing today. I'm going to have another attorney assigned to represent you, sir, for the sentencing portion of this matter. Okay?
Thank you.
Okay, the court's going to set this for, Allie, should we do June 1st? Oh, I guess it can be, and it doesn't have to necessarily be today. On Monday, it can be. Can you tell me which day we should select?
You want to put it about a month out? Is that what you can do June 1st. It works.
Okay, that's fine. Okay, we'll do, does June 1st work for you, sir?
Yes, Your Honor.
Okay. And I'm sorry, what time?
9:15.
Okay. And I went out just a little bit further, sir, so that way the attorney can get appointed to represent you and then have an opportunity to review the report and recommendation and the file and then even communicate with you as well. Okay? You're welcome. Bond and conditions are continued.
And Your Honor, just to clear the record, I noticed that I'm also one of the attorneys on schedule that day, so make sure my name will not appear on the docket for that.
For this case, correct. I wrote on here needs new MIDC attorney.
Thank you very much, Your Honor.
All right. Bond and conditions are continued. Thank you. Have a good day. Good luck to you, sir.
Anywhere.
I'm going to have you stop over at probation and they'll give you, and just in case they need to give you anything, okay?
Thank you.
You're welcome. Have a good day.
And that story continues, ladies and gentlemen. It's not over till it's over. He'll be back. He still has to get sentenced. He's getting a new attorney. It's crazy as a switch engine. I mean, argument whether or not he actually stops it. I don't know. I make the argument always that sovereign citizens are indistinguishable from mentally ill people. So generally, if they're given that, like, I'm better than everybody else and you have to buy into my BS, I'm going, that's just kind of a opposite kind of mentality to me. It's all mentally ill in the end, and for the most part, I think they all need evaluations. You don't just get to enforce your own personal perception on reality and expect reality to comport. That's not the way the real world works, especially on May the 4th. Be with you all, ladies and gentlemen. Thank you so much for hanging out with me tonight. It's been a pleasure bringing all of these court cases to you. It's been one thing right after the other. I don't know if you want to call our judges Jedi Masters or Sith Lords. I don't care. I really don't mind one way or the other. Just don't call them late for supper. Right, ladies and gentlemen? Right. Especially Judge Dad. Ever. Ladies and gentlemen, let's get on over here and see if we can do our little thing here. Find that little magic credit button. Hey, start those credits. Get them rolling. Hey, look at that. Tammy, Thank you so very much, those Sparkles and Marty and Steven. You all rock so much. I can't read all these names. Rhonda, I hope you get feeling better out there. I know you're feeling bad. Eileen, thank you for coming by. Raul, thank you for coming by. Marty. Lone Wolf, thank you for being here. I'm Lone Wolf. I'm confused now. Hi, all you guys. Thank you for being here. You're all really cool. Bad Boy is back again. Alex the Dane Mom was here. I saw Emma around here somewhere. There's Emma. Hey, Emma. And Hannah. And Kayla. And Larry. Here's Tammy again. Hey, Tammy. Mr. Peeps. Beep, beep. Hermeticus. I don't know what to say. I'm not any good at any of this. You know I'm not any good at any of this. I really could just put the credits on this screen right here. We could have it all done. I mean, it would just be a little bit overlooked, right? Nah. Who knows? Who knows? Ladies and gentlemen, it's been a crazy day of court cases. We got a lot more coming. There'll be some standalone videos coming out about 4 a.m. and noon tomorrow. We'll be back, same wolf time, same wolf channel. And I appreciate you very much. I'm your Lone Wolf Booster. I'm going to say, have a pleasant evening. And I'll see you next time. I am out. Oh. May the 4th be with you. All the way to Cinco de Cuatro. I get you guys.